Let's talk about some related questions that a lot of people have. One of the most basic aspects of our daily lives are the accounts that we use. We've got a basic checking account. Our paycheck goes into it. We've got maybe a savings account. This is the account through which all your daily transactions flow. And of course, that's very important to people. It's the debit card you've got handy in your wallet. And when people start to face a divorce, they often are fearful of what might happen with that account. So I get a lot of questions, both from people during their marriage as well as at time of divorce, about those basic daily use checking and savings accounts. One question, I'm going to address them all together because the answers are related. One question is, should I have, or can I have, is it okay for me to have a separate account, separate from my spouse? Or they have their own, I have mine. Is that okay? Should I do it? People also then ask, when I'm separating, is my spouse going to grab my money out of my account? Will I be able to protect it? What can I do in that way if we start to divorce? And the answers to all three of these start with the legal fiduciary duties that spouses owe each other, believe it or not. Spouses in California owe each other the highest fiduciary duties: good faith, fair dealing, transparency, loyalty. I'm not talking about the vows that people take socially or culturally or religiously upon their wedding. I'm talking about laws, something a lot of people don't know. Highest fiduciary duties in the laws of the state of California are between spouses. And so think about that when answering the first question. Should I have separate accounts? There's no problem if you do, as long as you do so in compliance with your fiduciary duties. Does your spouse know about the existence of the account? Do they know about the types of transactions that you're typically running through the account? That's totally fine. Lots of spouses, for many reasons, like to have separate accounts. It's nice to have somewhere, let's keep it positive and benign. It's nice to have a place you can buy your spouse a gift from without them seeing it show up on their register and knowing what you got them. And many, many other reasons. The autonomy that comes with having your own account. So it's totally fine to have separate accounts during marriage, as long as your spouse is at least generally aware of them, and as long as you're using it for transactions that are fine within a marriage. If not, you might find yourself subject, if you're divorcing, to a claim that you've breached your fiduciary duties to your spouse by misspending money. That could happen whether it was out of an account in your name or out of a joint account. The laws about what's community property or separate property don't change. The money, whether it's in a joint account or a separate account, if it's earned during the marriage, it's still community property. So now you're separating, and now you're worried, I need money. Remember that divorces can be driven by some bad motivations. People can make decisions out of spite, out of anger, out of stress, frustration, and fear. And so how people conduct themselves, especially with money, around the months leading up to and just after their separation are often going to come under a great deal of scrutiny. So just be mindful again of the fiduciary duties with whatever you do with accounts as you lead up to the days, weeks, or months preceding separation and that hard conversation about separating, and in the days and weeks afterward. I can never advise my clients to do anything more than to take control of half the balance of an account. If there's a concern that there may be a money grab, I am comfortable telling a client, okay, go ahead and take half, exactly 50% of whatever is in those accounts, and secure it for yourself somewhere else. I'm comfortable with that, that my clients won't get in trouble. Beyond that, I would want to get real specific with the proposal that a specific client has, and can't offer anything general there except be careful. When it comes to will your money be protected in the event of a divorce, the good news is that we're not talking about cash. It can't be lost, physically stolen, and then lied about as though it never existed. Even if somebody does some funny business with accounts, which actually, rest assured, is very, very rare, we can always track it down and look back at the statements, figure out what happened. You can't hide online activity and bank transactions and transfers of that kind. So I hope that helps answer some of the questions, fears, and concerns that people have about checking and savings accounts. In summary, big picture, no matter what you do, feel free to do it if it works for you and your spouse. You trust each other, but just bear in mind that when you're divorcing, everything you've done will be judged through the lens of the fiduciary duties that you owed each other. So just make sure you were transparent, you disclose the account, and the other side knows at least generally what it's used for. Thanks.